Hello and welcome to today's episode of You and the Law. Please subscribe to our channel. On the 9th episode of You and the Law, we discussed actus reus and mens rea. We saw that for an accused to be convicted of any crime, the prosecution must show that the accused person had the criminal intention to commit the unlawful act. Therefore, if the accused commits any act which is considered unlawful, but there is a justification for it, he must raise it as a defense in court. In today's episode, we will look at the defense of provocation and the requirements for a successful plea. The defense of provocation is based on the admission of the fact as established, and merely raises justification for the act. A person provoked actually intended the act, but was reckless as to the consequences of his act, because of his mental predisposition at the time of doing the act. Provocation is the act of making somebody angry by deliberately doing something annoying or offensive that tend to arouse rage and resentment in him, thereby causing the person to do something or an act in retaliation. Section 318 of the Criminal Code provides for the defense of provocation in case of murder, while Section 284 provides for the defense of provocation in case of assault. Section 222 of the Penal Code provides that homicide is not punishable with death if the killing is done under provocation. Homicide, which would otherwise be murder, is not murder, but manslaughter, if the act by which death is caused is done in the heat of passion, caused by provocation. Section 284 of the Criminal Code provides that a person is not criminally responsible for an assault committed upon a person who gives him provocation for the assault.
What is the difference between Section 318 and 284 of the Criminal Code?
In case of assault, a successful plea will lead to the discharge and acquittal of the accused person. However, in the case of culpable homicide, the defense will reduce murder to manslaughter. This is the provision under Section 318 of the Criminal Code. However, the Supreme Court's decision in Shanu seemed to have changed that position. In this case, the apex court discharged and acquitted an accused on a charge of culpable homicide on ground of provocation.
Are there any special requirements for the offense of provocation to succeed?
Of course. For the defense to succeed, there are basic requirements. 1. The victim must have done to the accused a wrongful act or insult. Wrongful act means something offensive, while insult may be by words of mouth, action, or by gesture. Words of mouth may amount to provocation, but such circumstances must relate to the situation in the life of the person provoked. 2. The wrongful act or insult must be serious or grave. In Rex v. Okiri, 1948, Waka, a wife taunted the husband with incompetence, and on one occasion, spat in his face. The husband killed her. He pleaded provocation in court. The trial court convicted the man of murder. However, on appeal, the West African Court of Appeal held that it was an insult for a wife to spit on the face of the husband. The sentence of murder was substituted for manslaughter. 3. The act of the insult must have been done to the accused himself, or to someone standing in conjugal relationship, parental relationship, master or servant relationship, or filial relationship. 4. The act or insult must be such that will make a reasonable or ordinary man to lose his power of self-control. 5. Retaliation must be directed to the person who did the wrongful act. It must be spontaneous, without allowing passion to cool, and it must be proportionate to wrongful act or insult. In considering whether retaliation is proportionate or not, the court will consider the weapon used, the degree of force, and the duration of time. Now, let us look at the case of Penal and Shanu versus the State, 2005, 8 SCM 128. On the 9th day of May 1997, at Akia village in Benue State, Nigeria, a woman named Shanu set her husband's mistress on fire. The mistress died subsequently as a result of the injuries sustained from the burns. Shanu was arrested and subsequently arraigned on a charge of culpable homicide punishable under Section 221 of the Penal Code. She pleaded not guilty to the charge on ground of provocation. The prosecution called for witnesses, including the husband of Shanu. Exhibits admitted in evidence include medical report, kerosene inside 4 liter of gallon, some burnt pieces of cloth, 4 liter of gallon, and the confessional statement of the accused. The accused person alone testified for the defense.
Please tell the court what happened in your compound on the 9th of May, 1997.
On that day, my husband arrived from Turin in the morning, and the deceased lady arrived at our house around 8 p.m. She went straight and joined my father-in-law in his hut. I was eating in the room with my husband when the children brought her bags into our room. My husband went to join her in the hut. I also went to greet the deceased. When I tried to offer her food, she declined. While we were there at 10 p.m., my husband noticed that she was feeling sleepy. He touched her and asked her whether she wanted to go and sleep, and she said yes. My husband asked me to go and prepare a place for her to sleep. I took her inside my room and arranged bed for her, and she slept on the bed, covering her face and body with cloth. My 2 children were sleeping in the other bed. I tried to sleep, but my mind could not rest, because of the deceased who have caused my husband not to do my part-time NCE course, not to farm for me, clothe me, take me and the children for treatment when the need arise, and his failure to pay my debts from my local bank. I had in mind to cause her some bodily injuries, in order to make her keep away from my husband, and so, I took kerosene in a container, poured it on her, and light matches and dropped it on her, and her body caught fire.
That will be all for the witness, my lord.
After the address of counsel, the court found her guilty of culpable homicide and sentenced her to death by hanging. Dissatisfied with the judgment of the court, she appealed to the Court of Appeal. Her appeal was dismissed. She appealed further to the Supreme Court. One of the issues before the Supreme Court was whether the defense of provocation can avail the appellant to reduce the offense from murder to manslaughter, considering the circumstances of the case. On Friday, the 18th of June 2004, the Supreme Court delivered its judgment.
The question raised by the issue of provocation is to be considered in light of the provisions of Section 222(1) of the Penal Code, which provides that
culpable homicide is not punishable with death if the offender, while deprived of the power of self-control, by grave and sudden provocation, causes the death of the person who gave the provocation, or causes the death of any other person by mistake or accident.
it is settled law that to avail himself of the defense of provocation, the appellant must have done the act for which he is charged in the heat of passion. The act must be caused by sudden provocation. The act must have been committed before there was passion to cool, and the mode of retaliation must be proportionate to the provocation offered. These 4 requirements must coexist before the defense can succeed. In the instant case, what is paramount is whether the act of the offender was done while she was deprived of the power of self-control by grave and sudden provocation. It is clear from the evidence adduced that the deceased had been the lady friend of the appellant's husband. It is also clear that her husband wished that she accepted his relationship with the deceased. However, a careful reading of her statement shows very clearly that she resented that relationship, more so, when she felt that it was that relationship that deprived her of the love and care of her husband to her family. It may be said that these are matters which a reasonable person should accept and carry on with life. Be that as it may, matters came to a head on the 9th of May, 1997, when at 8 p.m., the deceased arrived at the house of the appellant which she shared with her husband. It is clear from her narration that the appellant cannot be described as happy in all the circumstances. The question then is whether a reasonable woman would not be provoked seeing an acknowledged lover of her husband, and who had been the object of pampering before her, not be deprived of the power of self-control by the conduct of her husband and the deceased. In my view, it is the duty of the trial court to consider whether a reasonable person in such circumstances might be so rendered subject to passion or loss of control as to be led to use violence with fatal results. The trial court ought to have also considered whether the appellant was in fact under the stress of such provocation. It is after a careful evaluation of such facts that the view can be formed as to whether manslaughter or murder is the appropriate verdict. Though the court below did not approach the question raised as they should have done, the question then is whether the case be sent back for retrial. But having regard to the principles laid down in the case of Abotundu versus Queen, I do not think that a retrial be ordered. In the result, the appellant is discharged and acquitted. The judgment of the court below are hereby set aside.
Welcome back. We can see that despite the fact that the act of the accused caused the death of the deceased, the defense of provocation availed her. We encourage you to desist from all forms of crimes. Bye. See you soon.